What up, Dope Biz Nation? Hey, yo, court got a little heated today, man. Check it out.
We don't believe that they have met the, and by they I mean the opponents of disinformation coming in. They have not met their burden of showing that this statement from Onfunk regarding Nichols telling on himself and basically Nichols trying to get help for himself. Like bro needs to pay for a lawyer. We did it for him. We don't believe.
Hey, no, no, sir, Mr. Harvey, stop right now. Stop right now. Stop right now. Mr. Harvey, Mr. Harvey, sit down. I am not going to have you interrupt court. You may object in just a moment.
Yo, Biz Nation, as you can see, it got heated. Your boy Bruce Harvey was on a tear today. And also Max Sharp, man, he was really doing his thing. But the problem and the issue that the state, I should say the defense is having with the state, with these particular wiretaps that's going on, is the fact that there are so much hearsay and so much double hearsay or multiple hearsay that it is irrelevant when it comes to the furtherance of conspiracy theory. Now let's check out what actual double hearsay is first before we get into why the defense is actually arguing this point. Let's go ahead and do that real quick. All right, so it says right here, double hearsay, as known as hearsay within hearsay or multiple hearsay, is when a statement contains another statement and both are offered as evidence. For example, if a witness testifies about what someone else said and that person was quoting a third party, both layers of statements are considered hearsay. The Federal Rules of Evidence, Part 805, deals with the admissibility of double hearsay. Double hearsay is admissible if both parts of the statement are covered by a hearsay exception. For example, a hospital record might contain a statement made by a child's mother about how the injury occurred. The mother's statement is independently admissible as a statement made for the purpose of diagnosis or treatment under Rule 803(4). However, double hearsay is usually not allowed in court. Usually not allowed in court because it is not based on the witness's personal knowledge. For example, in Flynn versus Manhattan and Bronx Surface Operating Authority, 1984, a police officer testified as to what a bus driver told him about what he, the bus driver, had heard from a passenger. That testimony was inadmissible because the statement of the passenger did not fit within any of the exceptions to the hearsay rule. So basically, you cannot put into evidence, or it can't be evidence that what I heard was somebody else heard from somebody else. I heard it. Now you're going to use my statement as evidence because I heard what somebody else told me what they heard from somebody else. That is nestling hearsay. And so this is the reason why the defense was really just objecting and objecting and objecting a lot today, because it's too much layered hearsay. Let's go to the video. Let's see what they was talking about.
I think it's a bit of a it's not that it's a stretch, it's that you'd have to pile like, one building block on another to get to if some bad guy out there is following a cousin of your client, that must mean your client has committed some crime against a member of that group. I mean, yes, it could be, put together that way, but it's hardly like, oh, A equals B, therefore C.
Well,
it just isn't.
This conversation occurs days after a murder occurred that my client is charged with.
I understand.
And I think the state knows exactly why they want to get that in, and that's why they want to keep the reference to my client's cousin saying it. It's they want the truth of the matter asserted to be brought in front of the jury, and it's if their interest is just that they're aware, then there's no reason that they're aware that people are following, and there's no reason to include SB's cousin. They could just put in they could just put Quay or whatever. Quay said this, and they don't lose anything.
Okay, so what they lose is then they're just saying, hey, some random person is getting followed by a Durango.
Right.
And that's what they
Well,
don't want to lose.
in the context of the conversation, no, I don't think it's just some random person. It's obviously someone they're associated with and concerned about because they're talking about it. So it's not just some random person.
All right, I can listen to it again, which I don't need to do here. I will just circle back and listen
And-
to this one again.
And Your
okay?
Honor, I'd also point out that Mr. Shard is making a 403 argument.
Yeah.
And given that there's nothing about this belief on their part that is substantially more prejudicial than probative of the fact that they believe that this Durango is following a member or a family member of one of their group, and that belief is being shared, and in order that they do something, that they act accordingly. They're participating in the enterprise by.
Yeah, that's not his argument. His argument is that because the Durango is following a relative of Mr. Stillwell, that must mean that Mr. Stillwell committed the crime against their group a few days before, which is what I'm saying is a whole lot of building blocks having to be stacked on top of each other. But I will take another listen.
And it's not that it must mean that, it's that it's evidence of that.
And I mean, if it is, you know, it is. I mean, that's why the state puts up one case, and if the defense chooses, they put up another case, and in between there, they cross-examine all of the state's witnesses so that all of the different theories can get presented before the jury that all the sides want presented, and they can sort out what they believe to be the facts and apply those facts to the law.
But I'm not going to be cross-examining Demekion Garlington, and I'm not going to be cross-examining Quay.
No, but you are going to make a closing statement, I would suspect. So, I mean, it's how trials work.
Hello. Hey, what's up, bro? What's up? Yeah, B. Say what? Yeah, B. What's up, man? What the hell going? Man, shit, right here, listen to the new weapon. Huh? I said, right here, listen to the new young boy. What you got going? Can I? Yeah, you know, I can't hit you on that other phone. Shit, bro. I'm on that motherfucker. For real? Are you on? Oh, this another one? No, it's yeah, that's what I'm saying. Yeah. Yeah, bro. I know. I just, I ain't just like FaceTime how to say. That's what you right. That's what I ain't forgot about. I really can't respond, so I just like, yeah. I can't, man. They motherfucker tripping on them motherfucker. For real, man. Yeah. I said one shit. I said shit. I'm gonna go straight to my grandma house like that. I had to stay out of that motherfucker. Yeah. But yeah, she told me that I moved your style. Yeah. Right now, like what on know it inside? Nah, I'm with Free. You with Free? Yeah. Oh yeah, for sure. Yeah. They do the Free. They do. Yeah, they. Damn. Somebody said it. T-Rock was up there with you, huh? Yeah, T-Rock was downstairs with me. Yeah, cause somebody asked me in the hood. They're like, bro, down there with T-Rock. I'm like, ain't no T-Rock locked up. Yeah. What the hell we going up? Everything. What the hell? What's up with Tunk, man? What the hell he Tunk crazy like that? What do you think? Just Tunk crazy, man. All this little shit there. You talking crazy about Mal? No, it's about me talking about Mal and shit. But I ain't on TV. I ain't heard of that. Yeah, it's a lot of little shit I told, boy. Yeah. Had me blowed. They blowed? Had me blowed. Oh, yeah. I ain't talked to him, but the only person that be talking to is Mal. Yeah. Like, yeah, he be asking like what's going on. I'm like, yeah, I don't know. Yeah. What the hell? Like, order. Damn, bro. Like everything is smooth though. Yeah, I know it. I already know that. They just got them. They on Mal though. Yeah. Cause I don't know why the fuck he can get out the car. Yeah, that's what I'm saying. Like, that's what I was telling folks, bro. I'm like, shit, what the hell they locked up for? Like, they just saying, like, I'm like, bro, they good. I'm just like, they gonna assume some shit like that anyway. Yeah, they gonna assume that, like, y'all ain't did, ain't kill him, so.
That's what I keep telling Lil, I keep telling him, like, just chill. Like, I know,
Yeah, cause they
this
saying
ain't
he panicked.
nothing. Yeah, I'm like, this ain't nothing, bro. Like, they just doing that cut. They seen as a goddamn gas station. Like, just chill. You see what I'm saying?
Yeah. Hell yeah, man. That's what I'm telling. I keep telling my the same shit. I'm like, listen, bro. Just like you, like, bro. I'm telling folks in the cat. Listen, bro. No, just tell them for you don't want to talk, bro. Like,
Man, listen, bro. I told Baba, I'm like, hey, tell buddy, do the same thing I did when I went in there. I told him, for, hey, I want to see my lawyer. I want my lawyer. I'm going to say nothing else to me. So he got to do the same shit. Don't say not one word.
yeah.
Go down on what they try to portray or what they say, man. Don't say shit.
Hell yeah. I ain't know that though, but so I didn't. Tell my yeah. But they tell them like, hey, bro, but like hip hop just called, they're like, you heard? And I'm like, yeah, nah. I'm like, shit, I know. I'm like, I keep in contact through. You know what I'm saying? They folks. I'm like, I ain't turning on the phone. I'm like, he'll understand that anyway though.
Yeah, I ain't doing that anyway.
Yeah, I already know you ain't. I already know it. Yeah.
But other though, boy, I need you.
I know. I already know that. I told her like I told her $1,000. She said 800 for 1,000.
I told her like tell him I need 1,000, but anything in between, just got down.
Oh no, yeah. She ain't doing that, but bro, you know I got.
Yeah.
I know, like, but I talked to one call today, and she told me to tell y'all to like be patient, cause she hadn't had I talked to her. She DM me.
White.
Yeah. She like, man, just tell them like, man, no, we ain't gonna leave them folk like that. And I like, just tell them to be patient. It was a day, good morning.
Yeah.
Yeah. Man, just tell them to be patient, bro. Bro, I got it.
Well, I already know that part. I just like. I know like how that go. You know what I'm saying? I ain't really tripping on that. I ain't tripping. Like I've been just trying to keep Buddy calm. You know what I'm saying?
Yeah, do that, bro. Yeah, bro.
I don't really be liking that coaching and shit. That shit had me all out. Like,
I talk the phone. Like, I been on bro. Like, he had in FaceTime. Like, oh, what's up with Quay? Like, why the hell? I don't know Quay on the phone saying something. Like, I don't know if he on shit. Like, he told real, like, man, tell Buddy got there and get his lawyer, bro. We did that shit for him. He paid, you know what I'm saying?
what?
Yeah, that was phone told me. He like, bro, tell him, chill out, man.
Nah, I ain't know that about that.
Yeah, then we out downstairs. He was like, yeah, they was on the cell phone. But I ain't say nothing. So I'm like, I know I ain't even upstairs. I'm like, ain't even got access to no phone.
Hell nah, we ain't wasn't that like that. Nah. I don't think he said no shit like that though.
Yeah. But then I thought what that was telling somebody, what the hell she saying? Foreign farming.
Who?
She told him they talking about foreign farming.
I kept.
Yeah. She really kind of telling me to be careful. I was a corn out. And they with the little nigga. I ran into the boy little place by myself.
Yeah?
Yeah, I ran into him. Yeah. I ran into him by myself. Like, that's on TV showing the boy see me turn the head.
Yeah.
But like, yeah. But like, we was on live and Courtroom. Nobody be on my page and shit. So I don't know who told shot a video chat like, bro, when I ain't run. I say nigga, you ain't run. You damn sure turn your head, fat though.
Huh?
I say, no, I ain't say you ran. You damn sure turn your head when you see me though. Like,
Yeah.
I ain't know what you on. I'm like, listen, bro, you know what's going on. Like before all this shit, like shadow was straight.
Yeah.
I'm like, shit, bro, you know. I'm like, you know what's going on, like. He like, bro, ain't no problem with you, bro, with everybody. I'm like, listen, bro. You know how this shit is, bro. You know how this shit go. Like, I'm like, yo, I used to speak to you and everything. I'm like, shit, that ain't going on no more, bro. I'm like, yeah,
Yeah.
I'm like, yeah, that's on TV. I'm like, man, I had the corn right now. I told corn to be quiet.
Yeah.
Yeah. Yeah, but now they just made a video about an hour ago on Cleveland at the store with little sticks and shit like, yeah, all in our hood. I'm like, yeah, Chris saying,
Man, they on some, man. Oh, I be saying stay away from it. That's police shit.
yeah, man.
That's 12 shit. I ain't with that.
Yeah. Damn, man.
It's all good. Everything.
I know it. So you still ain't got nobody right now? Like they won't take no payment.
They ain't really saying it. But ain't really saying that. You just really like, just chill, be patient. Like, same thing White tell you.
Yeah. Okay. So I ain't been around like they say
They
no
would-
one ain't talking to nobody. Like they say they like, bro, I ain't never seen that nigga hurt like that, but that nigga hurt behind that shit.
Yeah. I think they said the one he really fucked with.
Yeah, I know it. Yeah, man. Everyone talk your ass too, bro.
Yeah.
Yeah.
What the
Nigga
hell?
That nigga work
What?
jail.
Who?
That.
I heard.
Yeah. No, I could be funny and put free wife and loose.
Yeah.
Yeah. All right.
They had no tell me that shit. I'm like, man, help 12 in here.
Man, what? Just phone them, say they call him, phone be slam on him. They say he working the police in the game shit. Like, they say like he got police, like he probably don't know, but like they no folk, like they watching his ass.
Yeah.
Yeah, like they finding his ass.
Mm-hmm.
Yeah. So they said they were gonna do it. We got 12 pulled them over some shit.
Yeah.
Yeah.
Yeah, that I don't chill something on him. I don't know what he on.
Yeah.
I'll tell him boy about this shit. I was like, man. He be like, you ain't gotta tell me, I already know, like, home be got him tripping.
Yeah.
Like on the other one, like he was like, man, I stand on more, man. I fought with, but home on the other, I think about that on some female shit.
Man, where? Man. Yeah, I ain't on DB. I ain't heard nothing about that though.
Yeah.
But I ain't even talk. Only time we talked to him, I talked to him that's like the same night y'all got locked up.
You gotta add when you call boy, you gotta add boy what he say, cause I can't really say like, cause she won't really just tell me like in detail, but she just beating around the book. I really be telling her, man, shut the fuck up
Yeah.
on that one night, cause I ain't going for that strain.
Yeah. But you know I got you, bro. I had a long trying to get down. I just had to take care of got down. I know I got you though, bro. You gotta got down the whole time, bro. I know how that shit is. Like I'm knowing like nigga need this shit. Like I ain't got you, bro. I'm here with you, man.
Yeah, sure.
Yeah, I'm trying to get.
I ain't gonna, like, I ain't gonna ask a word, but like, cause like, I don't even have to say your name. Like, she know who I be talking about. I don't be talking to nobody else, but I ain't gonna hit you on that motherfucker, like, ever. You know what I'm saying? But, everything really good, though.
Yeah. I'm like, I heard that shit. I'm like, what the fuck?
Yeah.
I'm like, bro, that shit was fast as hell.
Yeah.
Yeah, that's all it is, just assume.
Yeah, I already know. Like when they got down, go to wiping down, doing them got them they gunpowder, forensic, all that shit there.
Yeah.
You gonna come back clean. You see what I'm saying? So I ain't tripping on that. Yeah.
Yeah, bro.
Yeah, what the hell, swimming on? You still in yo.
Yeah. Okay, what is that?
You know what I'm saying?
ALC.
Who?
Who?
Yo, folk.
Yeah. I was like, what is yesterday?
Yeah.
Yeah, he got out of town now. He's gonna get ready to come back. I was gonna lie with the guy.
Yeah. You ain't talked all night. That whole night crazy, bro.
Yeah, I just talked to her today. I talked to her today.
Bro, that be
I
crazy.
was telling her, I'm like, he on the cell phone, like, he probably be over there, like, what not? She's like, what? You only thing you gonna tell on me? I'm like, hell nah.
She can't. I don't even be texting her back no more.
But she be texting on, like, on tab and shit?
Yeah, I don't even be responding to her. That crazy.
Yeah.
Hey, look, I'm finna get bro back his phone, right? I'm gonna get up with you though.
I do that, huh? I got you.
Right. All right.
I love you too.
Your Honor, the call is complete. So I don't know if defense has any objections to this call. I think the court understands the state's position of this. We've labeled it as a co-conspirator statement in furtherance.
Your Honor, Carrington Matthews again on behalf of Mr. Marquavius Huey. So there was a reference in this call again to a quay, and our position, as we stated earlier, is that it's a 403 issue that we're making at this time, as we did previously. We believe that this is a confusion, creates a confusion of the issues with this, the use of the name Quay constantly. The jury has heard the name Quay in this trial up to this point. They have heard it. We did file a motion for severance at a previous date. It was denied. I'd like to renew our request for a severance on this issue for the record. And on the basis, again, it's a 403 issue with respect to this word name Quay being repeatedly used. I think I've heard it like 3 times, at least in these series of calls. So on that basis, Your Honor, we believe that a 403, and if the court is unwilling to grant the severance under the 403, confusion of issues, confusion of evidence, I would ask this court to, again, reserve the issue to allow us to craft an appropriate 105 instruction that will address this issue.
All right.
Thank you, Your Honor.
Is there any response right now
Yes.
from the state?
Your Honor, Detective Viverito will clear up, I think, quite clearly that this is in reference to Defendant Nichols, not Defendant Huey, because when they're referencing, they're upset that on a phone call, Mr. Nichols says we did this for Big Bro, talking about the state's theory, Defendant Williams, in terms of what we did it, the murder of Shamel Drinks, who was, I've already described kind of the back and forth, but the testimony and the state's theory, so there won't be any argument at closing, and Detective Viverito, who is going to be introducing these wiretap calls, she will make crystal clear who that Quay is referenced on the call. So there won't be any confusion.
Okay, well, that'll cure any potential confusion. Just want to make sure that she does that. All right.
Am I correct in my belief that the state intends to introduce this whole call?
Sounds like it.
Okay, so my immediate concern is around 5 minutes and 30 seconds. Mr. Garlington is talking at this point, not my client. I talked to Funk. I've been with bruh, and he had me on FaceTime like, yo, what's up with Quay? And then Quay on the phone saying something like, I don't know if he on this SHIT, like he told Rel, like, tell buddy, god dang, get a lawyer, bruh. We did that SHIT for him. He paid, you know what I'm saying? Okay, so we got Garlington having talked to Unfunk, who is Mr. Greer, who supposedly, and I'm trying to put it together, it's not completely clear, but he talks to someone named Rel, and then somehow this comes back to Quay, who, you know, Mr. I think that the state is asserting is Mr. Nichols. So we have like a game of telephone with 4 different steps leading to Garlington then saying this to my client. And then it should be noted, my client does not tacitly acknowledge, or I think we've been using tacit admission. He says that doesn't sound right. So it's not that. He pushes back, and it's just nested hearsay times 4 in what Mr. Garlington's saying. So I have a real problem with that, because obviously that is someone who is not testifying to my knowledge, the originator of this, and it's passed around a few times, and it goes directly to my client's innocence or guilt. And it's, you know, this little bit in itself strongly suggests that my client is guilty, because the implication is Quay said we did this for Buddy. I'm not concerned about the for Buddy part. I'm more concerned about the we did this part. So that's a major flag right there. And it's nested hearsay. It's 403, any probative value that could come from this, other than its value as hearsay with 4 steps, is negligible. Clearly they could get out the facts that they're talking about attorneys without going into that segment right there that is extremely prejudicial to my client. So that's my first objection. I would also object that these other conversations about attorneys just generally are not furthering any conspiracy, but those don't. There's an extra level of concern regarding the time around 5:30.
All right, well, I think we've discussed the issue of attorneys potentially being provided by leaders already, and my ruling would be the same with regard to that. What is the state's response to the issue of it being hearsay inside of hearsay, the we did this part?
So, Your Honor, that this is a classic co-conspirator statement. This is one co-conspirator providing reassurance to, providing direction to, and promoting cohesiveness with another co-conspirator in furtherance of the conspiracy itself, which is YSL, the criminal street gang.
Right, but back up into this isn't just him, this is somebody else saying that, right? And
Yeah,
Mr. Shard at least is saying that Mr. Stillwell pushes back on the assertion. And this was a lot, so I might have to hear it again, but
Yes, Your Honor.
if that's accurate, then that seems like that couldn't be, oh yeah, this is an adoptive admission.
So, Your Honor, a couple things. One, defendant Stillwell is quite upset that Mr. Nichols made that. So the fact that Garlington and defendant Stillwell are discussing that, they need to know what's said on jail calls. They need to know who's talking to the police. They need to know who may fold, and they need to keep tabs on both members in jail and outside. So when they referenced earlier about Mr. Farley and how is he doing, and he needs to, so.
Yeah, that's not the part that they're raising, that Mr. Shart's raising an issue about right now.
You're specifically discussing, Your Honor. So defendant Nichols saying we killed him for bro, and Mr. Shard saying cannot come in this conversation with his client, Mr. Garlington. when they're discussing the intimate details of the murder that they did for bro, the state feels that, and this is why, and I will find the case on this, their conversation, Garlington and Shannon Stillwell, in all its contents, whether they knew this personally, they knew this from like that statement, their conversation is fostering cohesion amongst them because they both agree he shouldn't be saying that on the phone. And that's where co-conspirator 801D2E is a little bit unique, where this nested hearsay, if it's deemed a statement in furtherance of the conspiracy, keeping abreast of the crime, future, past and or future activities, fostering cohesion among street gang members, that type of analysis is incorrect. If you deem that statement and them discussing what one of the other co-defendants did in the murder that the state indicted both defendant Stillwell and Mr. Nichols with, and Mr. Garlington with, I think it is classic co-conspirator hearsay, which takes aside Mr. Shart's objection. The nested hearsay is not an appropriate analysis if you deem that statement, which the state believes it is co-conspirator statement. That's the state's position on this nested double
I
hearsay.
really need to see your
Yeah.
case law. on
Yes,
that.
Your Honor.
I
And
think
can we-
that's just an incorrect statement. of the law.
I would be surprised that it just makes what would otherwise be a valid evidentiary objection disappear. Maybe it does.
And so if it's hearsay, and I'd have to, like the court, I have to hear that little part again, but if they're saying that it's hearsay, that Mr. Nichols' statement about what they did is hearsay, and Mr. Stillwell is on the call,
Right.
right?
Yeah, this is Garlington and Stillwell.
Right. And when he says that his client pushes back, he's not saying we didn't kill him.
No, I don't know, but
That's
let's
what-
hear it again. There was a lot to unpack with this. Maybe it would have been better to take this in sections.
He
but-
says that doesn't sound right. And to push back, you don't need to repeat everything that was said and said, no, that's wrong, no, that's wrong, no, that's wrong. I mean,
Well,
that's,
I mean, it could have been in reference to whatever the
Tone of-
arrangements were for an attorney. I don't know exactly where that came.
But let's start with the proposition that it's Garlington and Shannon. Garlington is talking about talking to Funk, who had him on FaceTime. And that's what Mr. Nichols allegedly told Rel, which was repeated by Funk to Garlington. So, I mean, we're talking about layers upon layers. And this is the classic nested hearsay. You can't just say if one statement, the first conversation comes in, everything else in the world comes in. It doesn't.
Well, I don't think it does, but the state seems to think that there's law that says it does. So we're going to let them find that. And
So can we play it for the
if you just want to point me to wherever the original motion is or response is, I can read it on my own. But I mean, if that's easier than you trying to find it right now.
Your Honor, I'm trying to find both the date and the motion itself.
Them that be patient. It was a date. Good morning.
Yeah.
Yeah. Man, just tell them to be patient, bro. Bro, I got it.
Well, I already know that part. I just like, I know like how that go. You know what I'm saying? I
Yeah.
ain't really tripping on that. I ain't tripping. Like,
Yeah.
I've been just trying to keep Buddy calm. You know what I'm saying?
Yeah, do that, bro. Yeah, bro.
I don't really be liking that co-defendant shit. That shit had me all
Right.
out. Like,
I talk the phone. Like, I been on bro. Like, he got in FaceTime. Like, oh, what's up with Quay? Like, why the hell? I don't know Quay on the phone saying something. Like, I don't know if he on shit. Like, he told real, like, man, tell Buddy got to get his lawyer, bro. We did that shit for him. He paid, you know what I'm saying?
what?
Yeah, that was phone told me. He like, bro, stay home, chill out, man.
Nah, I ain't know that about that.
Yeah, then we out downstairs. He was like, yeah, they was on the cell phone, but I ain't even say nothing. So I'm like, I know I ain't even upstairs.
Can you play just maybe the last 30 seconds again?
I don't know, Clay on the phone saying something. Like, I don't know if he on shit. Like, he told real, like, man, tell buddy got and get a lawyer, bro. We did that shit for him. He paid, you know what I'm saying?
What?
Yeah, that was phone call.
You want to keep going?
He like, bro, stay home, chill out, man.
Nah, I ain't know that about that.
Yeah, then we out downstairs. He was like, yeah, they was on the cell phone, but I ain't even say nothing. So I'm like, I know I ain't even upstairs. I'm like, ain't got access to no phone.
Hell nah, he ain't wasn't that like that. Nah, I don't think he said no shit like that though.
Yeah. But then I thought what that was
All right.
telling me, I'm like, what the hell is he saying? Foreign farming.
Okay, thank you.
So, Your Honor,
Mm-hmm.
our position is that what he is pushing back against, and it's the context of that statement that is the most important, because they're trying to relay to keep someone calm, and that they were talking to Onfont, who was a co-defendant who pled guilty in this case, and they are alarmed at the fact that another member is potentially on a jail call saying that we did that for bruh. And that's the point at which Shannon is pushing back, saying like, what?
Right.
Like, I can't believe that. And then he's like, nah, he didn't do that. And the other guy says, I don't know, he could have been on a cell phone or what, but that's what I heard him say. So his alarm isn't at, he's lying on me. His alarm is that, and this is what we would argue, of course, anyone can make their own arguments at trial, but we believe that this is what the evidence shows, that the alarm is at the fact that this person on a jail phone is saying something highly incriminating to them and sharing this information between them all. And the alarm in itself is evidence of the fact that this whole conversation is in furtherance of that conspiracy, which is the enterprise that is YSL and the criminal street gang activity of YSL. So none of it is hearsay when all of it is statements of a co-conspirator. It is their reaction to their
It's
belief.
still hearsay, even if it's a statement of a
sorry, it's a
co-conspirator. So I mean,
exception.
at some point y'all are saying, this isn't hearsay because we're not offering it for the truth. So I know
I'm
that's not
sorry,
what you
I
meant, but
I
let's
missed
try
that.
to keep the terminology
Right.
clear.
You're right. You're very, very right.
And I didn't mean to interrupt you. I just want to make clear, like, we
You're
got
right. That's
we have got
important.
to all be clear about what we are saying and what we mean by what we're saying.
Your Honor is absolutely right.
All right.
And so that is, we are saying that there is an exception,
Right.
and that this is the exception that it falls under.
Okay. All right. And so again, I understand that the conversation between Stillwell and Garlington might come in under a co-conspirator exception to hearsay. The thing that is at issue is the relaying of Nichols allegedly having said, whatever he said, you need to line up a lawyer or whatever, you need to pay for it because we did this for Buddy.
Right.
And the concern is that either that part is being offered for its truth, or even if it's not, that certainly once the jury hears that, they take that as evidence that it is true.
Understood. So I
So
hear it more clearly.
do I understand you to be arguing that that part of that is also co-conspirator exception, or no?
There, I need to address that part of it. So one moment, Your Honor.
Sure. Do I have the argument correct that y'all are propounding?
Well, yes. And if while they're gathering this, Mr. Atkins is listening, I hope. So can I respond? If we break this down, here's what the sentences were. Garlington says, I talked to Funk. I've been with bruh. I don't know who that is. And he, I don't know whether that refers to Funk or bruh. And he had me on FaceTime. That could refer to either one of those people. What's up with Quay? That's the next question, next statement. Why the hell? I don't know. Quay on the phone saying something like, I don't know if he, and again, we got a he on shit. I don't know who the he is referring to. He told Rel, that's another person, that's another
But
layer.
that's somebody who's listening. That's not somebody who's talking. So anyway, and also, can I get this portion of what you've written down as a transcript? Because it would be most helpful.
I can give you what we have, yes.
Okay,
But,
great.
but I'm breaking it down because now we're on a third person. He told, I don't know. who
Okay,
he
but that's a
is.
listener. So keep going.
Okay, he told Rel, and I don't know who Rel is, and I don't know whether Rel told Funk, and I don't know whether Rel told
All
Bra.
right.
We have no clue.
Okay, but keep going.
Okay, he told Rel, like, tell Buddy, god dang, get a lawyer, bruh. We did that shit for him, he paid, you know? And then Garlington says, you know what I'm saying? To Garfield. To Shannon, I'm sorry. And Shannon says, what? And Garlington says, yeah, that's what Funk told me. He
Mhm.
was like, tell homie to chill out, bro. Now who's homie? And who's the bra? I mean, we have so many layers of unknown, and nested hearsay is exactly that. That's the whole point.
Okay, so the short answer is yes, I've got your argument
Okay.
correct in terms of understanding what it is you're arguing.
Yes.
Okay.
Your Honor, to be clear, because I may not articulate this well, my position with what Mr. Harvey
Mhm.
just broke down, at least what these statements they say.
Yeah.
Funk, who was a defendant in this case, and the state believes was a YSL street gang member, him telling Garlington that Nichols needs to chill. Funk isn't charged with the murder of Shamel Drink, so him telling him that is a statement in furtherance of the
Okay.
conspiracy.
Nichols needs to chill. That's not what I'm concerned about.
Yes, Your Honor.
Okay.
But
I'm concerned about the Funk saying, Garlington saying Funk told him that Nichols said he needs to pay. We did this for him, so he needs to get us a lawyer.
and Your Honor, the state feels
But said
And-
it to Rel, not to
It
Funk.
doesn't matter who he said it to. But it
Because
sounds like Funk heard it regardless.
No,
Do I have that part wrong?
I think you do,
Okay.
because he said it to Rel. Rel said it to somebody else.
Nichols said it to Rel,
Well,
allegedly.
Allegedly.
Allegedly, I understand.
Yes, yes. And then Rel to Funk, then Funk to Garlington. So that's 4 layers at least.
So, Your Honor, two things is, and the court may just disagree with my argument, which in terms of.
What I'd like is some law.
Yes, Your Honor. So the case law I was referencing earlier, I will find this date, but there's no double hearsay issue. The statements are admissible without a showing of the declarant's personal knowledge. And I may have been off kilter where I was thinking of, this is what I was thinking of when I referenced to the court, that there's not double hearsay in this statement, is that under, and I will just cite to this motion because the court can read this
Okay.
but I will find the date. But the state's position is that it is co-conspirator. It is in furtherance. Like the fact that Garlington is concerned or receives this information, that Nichols made that statement.
I understand that part. I
Yes, Your
agree
Honor.
with that part.
So the kernel, that part in the middle.
You
that-
understand what my concern is,
I
Ms.
do.
Love. You seem to understand it before, and I'm sure Mr. Atkins understands it too. He's just too busy looking up trying to find the law.
That,
But, yeah,
that-
go ahead.
that kernel in the middle, that Onfunk said, Nichols tells somebody, we did this for bro. Nichols saying, we did this for bro. Nichols saying, we did this for bro. I'll start out by saying, at best or worst, whichever you might want to look at it, Nichols is implicating himself and not Shannon necessarily. He hadn't said Shannon did anything. He's saying, me and somebody else did this for bro. So that's to start there. As to Mr. Sharp's argument that it necessarily implicates Shannon, who has to push back. Number two, Onfunk being a co-defendant of Mr. Nichols and a co-conspirator of Mr. Nichols, relaying what Mr. Nichols told to him. Whether or not Mr. Nichols said it or not, it's statements that Onfunk is asserting Mr. Nichols gave to him, even though it's a statement against the penal interest of Mr. Nichols. The reliability of the statement, the statement itself being the hearsay issue, we believe is dealt with in that it would be Mr. Nichols, a co-conspirator of Onfunk, relaying something in confidence to Onfunk or saying something in confidence to somebody else who he considers a person reliable enough to share something that inculpatory with. Onfunk is not trying to harm Mr. Nichols, so he's not going out lying on Mr. Nichols. He's sharing this information in an effort to help Mr. Nichols, get him to shut up and stop talking. They all are trying to get him to stop talking. So in terms of the reliability of the information, nobody here has any reason to share inaccurate information. It only furthers their purposes to be truthful about what's happening so that they can further protect themselves and inoculate themselves from any harm coming from this man talking. So the harms and dangers of hearsay that are normally present when, the whole reason it's kept out is, we don't know if it's true or not, are handled and dealt with by the circumstantial, I hate to use this, guarantees of trustworthiness given that are present in the way that this statement comes about. It's told in a way, it's relayed in a way that indicates it's shared in order to help, not to harm Mr. Nichols, to help all of them and keep them safe. So it's layered co-conspirator hearsay, if you will, but that first relaying of information, the declarant, Mr. Nichols, saying it to Onfunk, it would be definitely a statement against penal interest. But Mr. Greer, who is Onfunk, sharing that information is a co-conspirator statement, which we believe gets us past this idea that this is nested hearsay. And as far as the 403 argument that is being made, in order for it to be so unduly prejudicial as to permit its exclusion, it would have to lure the fact finder into declaring guilt on a ground different from proof specific to the offense charged. And that just doesn't exist here. So we don't believe that they have met that, and by they, I mean the opponents of this information coming in. They have not met their burden of showing that this statement from Onfunk regarding Nichols telling on himself, and basically Nichols trying to get help for himself. Like bro needs to pay for a lawyer. We did it for him. We don't believe.
Hey, no, sir, Mr. Harvey, stop right now. Stop right now. Stop right now. Mr. Harvey, sit down. I am not going to have you interrupt court. You may object in just a moment. We will get to your objection in a moment. Go ahead.
Thank you, Your Honor. There has been no showing that this information is so substantially more prejudicial than probative that it should permit the exclusion of what we believe is obviously relevant evidence.
Okay, thank you. Mr. Harvey, your objection.
My objection is for lying to the court, making things up to the court, and saying speculatively to the court that, why keep waiting for Mr. Nichols' lawyer? You got the evidence of that?
I don't even understand that to be what she said.
That's exactly what she said.
Okay, well, the record will reflect what she said, but I understood her to be talking about what was being said within the context of this conversation we just listened to.
Your Honor, just.
Yes.
Sorry. Go ahead, Mr.
And I missed any reference to it. So, well is the person to whom this allegedly.
I'm going to listen to it again. Offline, not in court.
Your Honor, this is where I'm at with this. Just because the state says something is so doesn't make it so.
I understand.
And the state is saying, oh, well, this was done in furtherance of the conspiracy. This was done in furtherance of the conspiracy. The whole point of the hearsay rules, and I understand that the confrontation clause might not be implicated here, but the hearsay rules, the whole point of the hearsay rules is you get to see who's saying it, know what their basis is. You get to cross-examine them. They come to court, etc. And the problem here is the state is just sitting here saying, oh, well, clearly Mr. Umfunk did this to further the conspiracy and clear. How do we know? How does she know? Maybe Umfunk, I'm not saying this is the case, but what if Umfunk was involved? Umfunk would have every reason to shift responsibility to other people. What about the next line in the hearsay ladder that we have? We don't know what people's motivations are. And just because the state says, well, their motivation was to do this or do that, she's not inside Unfunk's head. She's not inside Rel's head. So I reject that their argument that they can just label things as hearsay exceptions and it makes it so.
Well, I understand that. I take what everybody says as your argument in support of your position. I don't accept it as fact. It's an argument. I hear the counter argument. Sometimes I hear a lot more counter arguments back and forth after that. And then I make a determination about whether our evidence rules permit this particular evidence. The point of the hearsay rules and all of the evidence rules is so that to the extent the court can help it, only trustworthy information gets before the jury. And that's what we're trying to sort out here. So I understand that the stakes are high. I think that this might be a good time to break for the day.
All right, y'all. Y'all see how I got heated, right? So one of the problems that I noticed is this with Miss Love. The reason why Bruce Harvey got upset, her insinuating the fact that she thinks that the reason why, Nichols said what he said was because, he felt like he was trying to help himself out and get a lawyer, blah, 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 whatever, and all that kind of stuff. There is no actual factual evidence of that. That is not the case. You cannot insinuate your own personal interpretation of what somebody is saying in your own evidence. This is the evidence that you're trying to submit or you're trying to admit to the court, and you are implying your own personal interpretations to it instead of sticking to what the actual evidence says. And so Bruce Harvey took an offense to that, as he should have. And he was defending the fact that that lawyer Love keeps insinuating and lying basically to the court. Now, there is something that the judge said that was a very big misspeak. I hope she misspoke, but with this lawyer, you just never know. Take a look at this, and we're going to correct this.
I mean, that's why the state puts up one case, and if the defense chooses, they put up another case, and in between there, they cross-examine all of the state's witnesses so that all of the different theories can get presented before the jury that all the sides want presented, and they can sort out what they believe to be the facts and apply those facts to the law.
But I'm not going to be cross-examining Demekion Garlington, and I'm not going to be cross-examining Quay.
No, but you are going to make a closing statement, I would suspect. So
First of all, she spoke twice. First, she said something about the fact that you could cross-examine, right? That's the whole point of these cases, y'all, to cross-examine the witness and da-da-da-da, right? He said, well, I'm not going to be able to cross-examine. But she said, but you're going to be able to make closing remarks. Well, closing statements. That's not evidentiary. First of all, that's not evidentiary for the fact of you're actually, at that point, summarizing all of the evidence that came in. Evidence also include testimony. So what does a closing statement do? Let's check it out real quick. Says no closing statements. And I asked, I said, are closing statements used as evidentiary statements? No, closing statements, also known as closing arguments, are not considered evidence in court. Closing statements are opportunities for attorneys to summarize the evidence and persuade the jury to find in favor of their client. Attorneys can only rely on evidence that was presented in court. That would be done in the opening statement. And they can't ask the jury to consider any other factors. Attorneys should be careful not to make statements that aren't based on the evidence. Hello, Ms. Love? Your statement should be based on the evidence, not what your interpretation of what you think somebody was saying at the time they were saying something. And the judge will often remind the jury that openings and closings are not evidence. The opening statements are to present evidence, but the evidence is in the case. Closing statements differ from opening statements, which preview the evidence that the attorneys expect to present. That's the opening statement. Closing statements summarize the evidence that the jury actually saw, and they can help the jury recall important evidence from the beginning of the trial. So that is what that is. She said, well, you're going to have your closing statements as if that's equivalent to being able to cross-examine someone that's mentioned in evidence that's not going to be able to be cross-examined. So how are we going to know what's the truth and what's not the truth? All of this have an odor of mendacity, and that's the reason why a lot of people don't have faith in the state of Georgia, in the federal system, in the court system, period. This is the reason why we don't have faith. It's because you all do not have to know candor to your own laws that you make and break, by the way. You know what I'm saying? So let me know what you think about this video, man. Go ahead and like, comment, share, subscribe to the channel. And look, man, this your boy Tay Biz, man. Tay Biz TV. This is Biz Nation. I'm going to holler at y'all later. I'll see y'all in the comments. All right. Peace.